Hi everyone, I'm Sabrina.
And I'm Jonathan.
And we are the lawyers at Marital. Many people believe that buying real estate is a one-time thing. You go to the lawyer's office, sign a bunch of documents, and then you're done.
Well, actually, there are 3 different ways of owning real estate, each one leading to a completely different result. Today, we will use the story of Cinderella by Grimm Brothers as an example to show that real estate purchases require planning. How you go on title may create ripple effects 3 generations down the line.
So, Cinderella's father owns a beautiful family home. Unfortunately, her mom passed away in sickness. Several years later, her father married her stepmom, who has 2 children of her own. After the marriage, the stepmom consulted an experienced lawyer and learned about the 3 different ways of owning real estate. Those choices can be made at the time of purchasing the home, or in this case, after the purchase, as long as the property owner and the stepmom both sign an agreement. So John, what are the 3 choices?
Well, the first choice, stepmom and dad own the property as joint tenants. After dad passes away, stepmom will become the only owner of the property. She will own 100%. Cinderella will not receive any part of the inheritance. Choice 2, stepmom and dad own the property as tenants in common, meaning they each own a percentage of the property. For instance, stepmom could own 50% and dad owns 50%. After dad passes, stepmom's ownership remains unchanged. She does not get dad's 50%. Instead, dad's share gets passed down according to his will or to estate law. If dad wrote a will giving everything to Cinderella, then she would get the 50% of the property. With choice 3, stepmom did not go on the deed, so the deed only has dad's name on it. However, because stepmom married the dad and they live in the property on a daily basis, the property became their matrimonial home. After the dad passes, the stepmom can use family law to gain possession of the home. She can even register a declaration of matrimonial property onto the house to ensure that she gets part of the property because she is the spouse.
Okay, so from those 3 choices, choice number 1, joint tenancy, is the best choice for stepmom. She tried to convince dad to do this, but dad chose number 2, tenants in common instead. This means that dad owns 50% and stepmom owns 50%. Why did dad do this? Well, he wanted to ensure Cinderella can have a part of the property when he passes. But you know what? Stepmom doesn't need to be too upset because it takes more than just joint tenancy to give her the entire property. Whether there is a relationship breakdown may outweigh joint tenancy. Now, in the recent case of Pescar Estate and Wagner, although the married couple held the property as joint tenants, the court ruled that joint tenancy no longer applied when their marriage broke down and they started fighting over the property. In this case, the court ruled that their joint tenancy was severed and the deceased father's 50% will not go to the other joint owner, but instead will pass down according to estate law.
Very interesting. Unfortunately, later, Cinderella's dad also passes away. He wanted to do a will for a long time, but never found the time to do it. So now, the estate would be passed down as if there is no will, meaning first, stepmom still owns her 50% of the property. Then, Cinderella needs to apply to the court for an approval document to get her share. Since there is no will, this means the stepmom would receive the first $350,000, which is called the preferential share. From the leftover amount, the stepmom and Cinderella each receive 50%. So let's say the property is worth $1 million, meaning dad's half is $500,000. From this, the stepmom receives that $350,000 preferential share, and the remaining $150,000 is evenly split between Cinderella and the stepmom. They can either sell the property and split the cash, or they can update the deed to reflect this new ownership.
Although stepmom received most of the property, she's still unhappy. She wishes to receive all estate assets with her own 2 daughters. She made an argument to the court stating that her own daughters are also the dad's children, being his stepdaughters, so they should receive a share too. However, the court stated that to get a part of the estate, the children must be related to the deceased father by blood or adoption. Another matter is making stepmom angry. If the property was held as joint tenants, then she does not need court approval to receive the estate as long as there is no marriage breakdown. This also means she doesn't need to pay the 1.5% estate administration taxes. But since the property was held as tenants in common, she must pay this tax.
Interesting. Now, fortune finally befell Cinderella. She went to the ball, fell in love, and married the prince. After that, the castle became her matrimonial home. Let's ignore laws relating to royalty for now and just treat the castle like any other house. As Cinderella moved into the castle, she left her dad's house. This means the castle is now her matrimonial property and principal residence, and the dad's house became her investment property.
After a few years, stepmom wants to sell the house. Since the house is stepmom's principal residence, she is not taxed on the sale proceeds. But the house is Cinderella's investment property. Cinderella must pay capital gains on the sale proceeds. Cinderella learned from her past experiences and insisted she be added as a joint tenant to the castle. The prince agreed. Cinderella and the prince lived happily and gave birth to a beautiful daughter. Tragically, the prince passed away during a hunting trip. As Cinderella owned the castle as joint tenants with the prince, she only needs to go to a real estate lawyer and update the deed. She is now the only owner of the castle. She does not need to get court approval and does not need to pay probate taxes.
After everything that happened, Cinderella completed her will immediately, stating that first, all of her assets, including the castle, shall pass down to her daughter. Second, the assets that her daughter receives from the will shall not become her matrimonial property. This means that if the daughter got divorced, those assets would not belong to the spouse. Third, the will has a specific bond clause stating that the court should not ask the daughter to buy bond insurance, which may require her to pay up to 5% of the entire estate.
But there is an exception to that family law clause. If her daughter decides to use the castle as a matrimonial home, meaning the daughter lives in there with her spouse on a daily basis, then her spouse may still have a claim for the castle when they get a divorce. It does not matter if her daughter's husband is not on the deed to the castle. As long as he can prove that it's a matrimonial home, then he is entitled to half the property. This is true even if the daughter decides to sell the castle, as the court may rule that 50% of the sale must be held by her real estate lawyer in trust, pending family law litigation. This point was confirmed by the recent case of SCH and SR.
Interesting. Now, to overcome this problem, Cinderella could encourage her daughter and son-in-law to purchase their own property and live there. That way, their property is the matrimonial home, and the castle becomes the daughter's investment property. This means, according to the will, it won't be split upon a divorce.
But now there's a problem with capital gains. As the castle is the daughter's investment property, when she sells it, there will be capital gains tax. A solution is that the daughter can sell the castle in Cinderella's name in the year that she passes. Although Cinderella is no longer here, her daughter can sell the castle under the estate of Cinderella. As that's Cinderella's principal residence, there's no taxes on the sale. And since there's no inheritance tax in Canada, the daughter can receive the money from the sale tax-free.
Evidently, the three choices of how to own real estate may affect 3 generations of your family. Making the right decision from the beginning to the end is crucial. We invite you to contact us using the information below this video and book a first free consultation.
That's it for today. We will see you in our next month's video.